next topic is regarding procedure for obtaining patent. That is, once you have found that you have an invention that could be patented or that doesn't fall under the exceptions under section 3 or any other exceptions whatsoever. So in that regard, you are quite sure of getting a patent, or you might not be sure but then you're desirous of getting a patent. Then what is the next step forward? So this flow chart shows the next step forward. First you have to file an application with the patent office. Next they'll after few months or after the expiry of a particular time period, they'll publish the particular application. In the particular application along with the invention will be thoroughly examined by the officers and examiners. Then there will be search for anticipation, that is to check whether the invention has yet formed part of the prior art or does it form part of the state of art. Was it anticipated before? Was it obvious to the public? So all these questions are to be dealt with. Next one is oppositions are invited. This invention is not a one-way process that somebody is claiming to get an invention, getting an invention patent, and soon that their claim is given off. It's not something like that. Any oppositions from the parties will be invited and they will also be heard. Both the patentee as well as the opponents will be given fair share of fair hearing process will be held, and then after the opposition process is over, the patent will be granted. So this is quite a lengthy process, quite a sophisticated one. So we look into one by one. So this procedure is different from that of copyright, because under copyright, soon after a work, an original work is done, you need not get a copyright. You don't need to go and register in the office itself. Of course, it is quite recommended one, but it is not compulsory to get copyright protection. Only thing is that registered copyright users will have an upper hand over the unregistered ones, but that doesn't mean that the unregistered copyright owners are left with no remedies. They are also given remedies. So here the procedure is lengthy. The procedure in the patent system is lengthy. There is no ipso dixit claim of patent, nor there is suo motu grant of patent by authorities. So I've already mentioned, because only after these processes are thoroughly and religiously followed will the patent be granted. So next, let's see the first process, that is the application process. Now we know that patent protection is given for a period of 20 years, subject to the fulfillment of certain conditions. Now who can apply for a patent? So that'll be the first question. Who can come up with the claim of patent protection? First one is a true and first inventor. True and first inventor is any person claiming to be the true and first inventor of the invention. That true and first inventor has to be examined in such a manner that it is not the person who came up with the idea, but rather the person who came up before the patent office with the claim. He will be the true and first inventor. Suppose an invention might be worked by two inventors simultaneously. Maybe the first person would have invented it in time. If you look at the chronological order, he would have done it in time, but then the next person would have approached the patent office faster than the other person. So in legal sense, the person who comes before the patent office seeking patent protection will be the true and first inventor, irrespective of actually who completed the invention or not, or irrespective of who was first in time in doing the invention. So that is regarding true and first inventor, that the first person to disclose the invention before the patent office will be the true and first inventor. Next, any person being the assignee of the person claiming to be the true and first inventor in respect of the right can also make an application. That is, the assignee can also make an application. Next one is legal representative of any deceased person who immediately before his death was entitled to make such application. So these are the three categories of people who can come for patent application. Now the question is, who is a person? Person in the ordinary sense need not be an individual person as such. It can be a company, an association of persons, partnership firm, uh, etc. It can even be a government because under the Patent Act, a person includes government also. So all these people are included under the term patent, and most often the assignee of the true and first inventor will always be an education institution, a research organization, a government registered company, etc. in most of the cases. So they can also come and get the patent. Even assignee includes an assignee of the assignee and the legal representative of the deceased assignee. So assignee is given a wider import, the assignee of the assignee and even the legal representative of the deceased assignee. They can also come within the purview of applicants. Next one is form of application. So form of application, there is a detailed form. Every application for a patent shall be for one invention only. Sometimes there will be a lot of inventions, but then you cannot include all the inventions in one application. If you have more than one application, more than one invention, then you will have to apply more than one application. An application is to be filed in the patent office. Mumbai is the headquarters, but there are Mumbai, Delhi, Chennai, Kolkata, depending upon the territorial jurisdiction. Territorial jurisdiction of a patent office is based upon the place of residence, the domicile, place of business of the applicant, and even place from where the invention actually originated. So depending upon that, if any person from Kerala wants to file an application, he'll have to go to the Chennai patent office. Next one is international application. Now international application, suppose a US citizen is making an invention and he wants patent protection in most of the countries, in almost all the countries. So what is the procedure? He cannot go to every country and file the patent application because in different countries there are different methods. So it is total waste of time for him to go to every country and look at the patent procedure. So now to avoid this dilemma, we have Patent Cooperation Treaty. It is an international patent law treaty of 1970. That is, by filing one international patent application under the PCT, applicants can simultaneously seek protection for an invention in a large number of countries. The advantages are as follows. There is no need for filing a multiplicity of separate applications. The international search and international preliminary examination give applicants a better basis for deciding whether in which countries to pursue their applications, thus allowing for better management of patent portfolios and the avoidance of unnecessary expenses. It also allows deferral of national processing. Now, PCT procedure is done in phases. There is an international phase and a national phase. In the international phase, a single patent application is filed with the patent office of a contracting state of the PCT. One thing you have to notice that only the states that are party to the PCT can be involved in this system of arrangement. That is, if a particular country is not a party, then you cannot have a single patent application. Next one is national phase, continued by filing necessary documents with the patent offices. This is the second phase. It is continued by filing necessary documents with the patent offices of separate contracting states of the PCT. Now, after that, you have to go to every country and get the procedure checked. But the application can be done in one single go. So that is the major advantage of PCT procedures. Next one is specification. Now there are two specifications, provisional specification followed by complete specification. Let's see what a provisional specification is. Provisional specification is a techno-legal document. Both are techno-legal documents. Techno in the sense that all the details from A to Z details of the invention is to be disclosed in the particular document. It is a legal document in the sense that it has legal validity in the eyes of law. Now, invention has reached a stage wherein it can be disclosed in paper, but it has not reached the final stage. Now, provisional specification need not describe the invention fully and specifically. It has reached a particular stage where it can be disclosed in paper. That is enough for any kind of provisional specification. The benefit is that it secures a priority date, preference over other inventions. So if you feel that there are other inventors working on this invention, then you can get the priority date over the other ones. What are the contents? PS needs to contain only a description of general nature of invention, its field of application, manner of execution, and anticipated result. It is not a rough draft or a skeleton of the CS. It is a permanent and separate document itself. Within 12 months from the date of filing of application, complete specification shall be filed. If not, application shall be deemed to be abandoned. So with the application filing itself, you can give the provisional specification, or within 12 months you can file the specification. But within 12 months, after the expiry of 12 months, you have to give the complete specification itself. Next one is complete specification. Complete specification is an extremely important document in the patent proceedings. It should be drafted with utmost care and without ambiguity. And it is a document to describe the best method of performing the invention. That is, any person skilled in the art or skilled in the particular field of application, when that person reads the complete specification, he should be able to perform the invention. That is the importance of complete specification. That lucid should be complete specification. Excuse me. Next one is the contents of complete specification. Now these are the contents of complete specification. First one is a title. Title, as you all know, should be sufficiently indicative of the subject matter of the invention, and it shall disclose specific features of invention. It shall be very brief, not very fancy, or it should not be ambiguous. It should be very precise and definite. And it should not ordinarily exceed 15 words. But if it also goes long, it's okay, but then preferably 15 words. Next one is field of invention and use of invention. It should start with the general statement of the invention so as to indicate briefly the subject matter to which invention relates. That is, invention relates to the particular field of application. Next, advantages of the inventions may be mentioned to bring out the clear areas of application and the preferable use of invention. And the applicant may substantiate industrial applicability of the invention on this part. Next one is prior arts and problems to be solved. Sometimes there could be prior art. So, if the invention is an addition to the prior art, which is not obvious, then what problem is to be solved or sought to be solved to this invention is to be clearly mentioned in the complete specification. But the description should fully and particularly describe the inventions by clearly distinguishing it from such a closest prior art known to the applicant. So if the closest prior art is known, he has to clearly distinguish it from the existing prior art, and how the invention that he seeks to get patent protection is different from the existing prior art. Next one is objects of invention, that is, what are problems associated with the existing technology and what are solutions he's bringing out. The differences between claimed inventions and the prior art. Next one is a summary of invention. Next one is a detailed description of the invention. Detailed description, which means all the necessary requirements for conducting the invention. The nature of improvements or modifications effected with respect to the prior art. Next, the details of invention should be sufficient for a person skilled in the art to perform the invention. It can include drawings, samples, etc. And it should also contain the beginning of the description, a definite statement indicating the improvement or modification of the original invention, the serial number of the application for patent in respect of original invention. So that is the most important part, that is a detailed description of the invention. Next one is drawings, models or samples to support the detailed description. It is not necessary, but if it could be provided, it is so preferred. Any illustrations, such drawings should be on separate sheets Drawing should be prepared neatly and clearly on durable paper sheet. Next one is an abstract. Every complete specification is to be accompanied by an abstract to provide technical information to the invention. The abstract is to commence with the title of the invention. It is to be drafted so that it constitutes an efficient instrument for the purposes of searching it in the particular technical field. In particular, by making it possible to assess whether there is a need to consult the specification itself. And the abstract shall contain a concise summary of the matter contained in the specification. The summary shall indicate clearly the technical field to which the invention belongs, technical problem to which the invention relates, and the solution to the problem through the invention and principal use or uses of the invention. And the abstract shall not contain more than 115 words. So within 150 words, all these things are to be included in the abstract. Next one is a claim, that is a claim for patent. What claim is the person making? It is a statement of technical facts expressed in legal terms defining the scope of the invention so to be protected. Sometimes the whole of the inventions cannot be protected. Certain things might fall under the exception. So what exactly is the person trying to seek protection, patent protection? So the claim is also another most important part of the patent application in the legal sense, as it defines the scope of legal protection. In a patent application, claims must be drafted carefully to cover all the aspects of the protection being sought at the same time. Claims must not be too broad to embrace more than what the applicant has in fact invented. A claim which is too broad may encroach upon the subject matter which is in public domain or belongs to others. A claim may not be too narrow because such a claim would not be sufficiently effective against potential infringement. So each claim is evaluated on its own merit, and if one of the claims is objected, it does not mean that the rest of the claims are invalid. It is therefore important to make claims on all aspects of the invention to ensure that the applicant gets the widest possible protection. And the last one is declaration as to inventorship, and also if any international applications are also given, that is also to be given in the complete specification. A declaration as to inventorship shall be in the prescribed cases be furnished with a complete specification or within prescribed period after the filing of the specification. So this is regarding the application and the specification that follows it. Thank you.